Hello, I'm Brett Panter from the personal injury law firm of Panter, Panter, and Sampedro. We also focus and specialize in medical malpractice actions. Today I'm here to talk to you about when you can bring in medical malpractice action and when you can't. Generally, we have what's called a statute of limitations in Florida. It is evolved from an actual statute, Florida Statute 95.11. But that statute allows most negligence actions to be brought within 4 years from the date that the negligence was committed. But the medical malpractice statute is much shorter and much more restrictive. And what it says is you must bring an action within 2 years from the date you knew or reasonably should have known medical malpractice occurred. So what does that mean? When we get a call from clients and they tell us that someone in their family has suffered from medical malpractice, the first question we ask is, when did it occur? And if it's more than 2 years, most likely we won't take the case, even though the statute says it's 2 years from the date you knew or reasonably should have known. So then that becomes a fact question. But then the next jump is it's never to exceed 4 years. So it's 2 years from the date you knew or should have known, never to exceed 4 years from the date the malpractice was committed. But then, as law is, it's complicated. There's another exception. And what the statute says is it could be 7 years. And what do I mean by that? If there was, and you can prove it, fraud, concealment, or intentional misrepresentation of fact prevented the discovery or the injury, the period of limitations extends forward 2 years from the time the injury is discovered or should have been discovered with the exercise of due diligence, but not to exceed 7 years. And I want to go back to what I said at the beginning. When we're evaluating a case, 99% of the cases we want to take if their statute of limitations has not expired. In other words, 2 years. That's going to be most cases, 99%, 2 years from the date of the actual medical negligence. There's another exception to make it even more complicated. If your case or your family's case involves a minor child, there's a statute, and it was founded by a case by Tony, a young child. It's called tolling for Tony. And what it says is you have 8 years to bring a case. In other words, when the child is 8 years old, if he's 8 years in 1 day, you're done. But if it's up to 8 years, up to the 8th birthday, you can still bring a medical malpractice action for a child. And why is that? There's a reason behind that. Because sometimes child's injuries that maybe occur at birth are not very well detected, very difficult to determine if a child has brain damage in some cases. Some cases it's quite obvious. So what do we have in review? We have a general 2-year statute of limitations in medical malpractice cases, but it can go up to 4 years because it's from the date that you knew or should have known, and 2 years from that date. Then we have the next level is 7 years if there's fraud or misrepresentation. Then we have 8 years from the day up till the child's 8th birthday. This is all somewhat complicated. Some of this becomes a factual issue for a jury, but to be safe, if you feel that medical malpractice is committed upon you or a family or a loved one or a friend, it's my suggestion that you contact a lawyer without any delay to avoid losing all your rights, because statutes are construed very strictly, and you could lose all your rights if you don't pursue your action in a medical negligence case within 2 years.